Can you get a DUI on private property? Driving under the influence in New Jersey doesn't just apply to highways or public roads. Many people are surprised to learn that you can be charged with a DUI even while on private property. Understanding how state DUI laws apply in these situations is essential for anyone who operates a vehicle in the Garden State. Private property, such as driveways, parking lots, or even residential estates, doesn't offer protection from DUI enforcement. In New Jersey, if you're behind the wheel and impaired, the law still applies, regardless of where your vehicle is located. This is because the state prioritizes safety and aims to prevent accidents wherever they might happen. If you've been charged with a DUI on private property, a knowledgeable attorney can review the facts of your case and help you mount an effective defense. Legality of DUI charges on private property. New Jersey law under Section 39 to 450 states that DUI laws apply broadly, including to incidents on private property. This includes driveways, parking lots, or private roads that are accessible to the public or visible from public areas. Courts in New Jersey have upheld DUI charges even where the vehicle wasn't moving but the driver was behind the wheel, keys in ignition, or showing signs of intending to drive. Probable cause is required for any DUI arrest, and officers must have a lawful reason to enter private property. This may include obtaining consent, identifying imminent danger, or observing from a legal vantage point. If the entry is found to be unlawful, any resulting evidence can be challenged in court. However, the fact that the offense occurred on private property alone does not make a strong defense. It is critical to evaluate the officer's actions and your own behavior to determine whether a legal challenge is viable. Can you get a DUI on your own property? Yes, you can. If you're intoxicated and operating a vehicle on an area accessible to the public, like a shared driveway or a private road, New Jersey law still applies. The law emphasizes the act of driving under the influence, not necessarily where it's taking place. You could be in your own driveway, intending to drive, or even just sitting in the driver's seat with the engine running. If law enforcement determines you had the intent to operate the vehicle while impaired, they can pursue charges. This is due to safety concerns and the real danger intoxicated driving poses, even on private land. The same principle applies if you are sitting in a parked vehicle on private property. If you have control over the vehicle and show signs of impairment, such as slurred speech or erratic behavior, police may view it as intent to operate the vehicle while impaired. How does intent to operate affect DUI cases? Intent to operate is a key element in DUI cases on private property. Courts don't need proof that the vehicle was in motion. Factors that establish intent include being in the driver's seat, having the keys in or near the ignition, or making statements about driving. Physical signs of intoxication can strengthen the case for intent. Even if you were planning to sleep it off in your car, the presence of keys and your position in the vehicle might lead to a DUI charge. Intent does not require you to be actively driving, it's about the possibility and likelihood that you were preparing to do so. Understanding and challenging the specifics of intent to operate can be one of the strongest components of your defense. That's why working with a lawyer who understands the nuances of DUI law in New Jersey is vital. A seasoned attorney can dissect the facts and determine whether the prosecution has sufficient evidence to prove intent. Your next steps if facing a DUI on private property, whether you were found in a parked car, sitting in your own driveway, or encountered law enforcement in a private parking lot, you can still be charged with DUI. However, every case has unique circumstances. An experienced attorney will examine whether law enforcement acted within their legal bounds, whether field sobriety tests were properly administered, and whether your intent to operate can truly be established. Getting a DUI on private property is serious. Criminal penalties, license suspension, and mandatory installation of an ignition interlock device are just some of the consequences. A strong legal defense begins with understanding how these laws work and working closely with a lawyer who can defend your rights effectively. For personalized guidance and strong legal representation, contact the Kugel Law Firm at 973-854-0098. Visit them at 1 Gateway Center number 2600, Newark, New Jersey, 07102, United States.